The rule of law. A simple Google search will tell you essentially that nobody is above the law. While you've heard that many times in blockbuster action movies, we're not Sylvester Stallone, or The Rock for that matter. We actually have to follow this. I'm Lewis from the Thinking Bubble, and this is the rule of law, bite-sized. So, what is the rule of law? And how does it actually work? I think it all begins with the meaning. The rule of law's meaning has developed over time. It has changed its meaning in direct correspondence with the beliefs of those who claim its support. The state has increasingly taken over regulations of many areas of social activity, such as nowadays with the pandemic going on, advertisement campaigns in the UK have plastered that it's illegal to gather, among other rules they have passed through. In doing so, the government has had to delegate discretionary powers to various people and bodies to make sure that its policies have successful implementation. I mean, the fundamental nature of the concept of the rule of law has always been central. The Constitutional Reform Act, for the first time, recognised the centrality through statute section 1, stating, in section A, the existing constitutional principle of the rule of law, or, in section B, the Lord Chancellor's existing constitutional rule in relation to that principle. Now, unlike the simplified definition that Google mentioned, the rule of law is difficult to give a definition of. Many academics have gone into what seems to be maddening depth into defining this symbolic principle. So I'll give you a brief summary of their opinions and maybe you'll actually agree with one of them. Now, according to Albert Dicey, the UK has no administrative law. The rule of law is one of the key features that has distinguished the English Constitution from other counterparts. They have done this with 3 elements. The absence of power on the state is one of these elements. The power is limited and controlled by the law. Equality of the law is the second element. With what Google said earlier, no person is above the law, irrespective of rank or class. Finally, the supremacy of ordinary law, with the fact that the English Constitution was the outcome of ordinary law of the land based on the provision of remedies by the courts rather than a declaration of rights in the form of a written constitution. Essentially, remedies by the court. According to von Hayek, who has the manliest name in existence, he actually followed Dicey in seeing the essential component of the rule of law being an absence of power towards the state. Academics agreeing with each other. Who knew? Hayek puts it that the rule of law puts limits on the scope of legislation as it restricts the rules of formal law and excludes laws being directly aimed at individuals. Hayek comes from an economic mindset in which efficiency is key. The state cannot understand one single individual's situation and therefore should leave the individuals to make their own decision. This is because they can never possibly achieve it in the way that every individual would want from a legal perspective. Hayek actually believed that the state would leave less room to make individual decisions. It reduces their freedom. Now, Thompson believes that it is a mixture of implied promises and convenient vagueness. Thompson goes on to say that the vagueness of the rule of law is just the necessary means of limiting potential abuse of power, but that the rule of law itself, the imposing of effective inhibitions upon power, and the defense of the citizen from all power, all intrusive claims, seems to be an unqualified human good. Josephraz, a name you'll see a lot if you study law in the UK, he actually recognises the need for state intervention in contemporary society, and has provided ways of understanding the rule of law as a means of controlling discretion without attempting to eradicate it completely. In his piece, he says that the need for the government of men as well as laws as the pursuit of social goals may require the enactment of as well as general laws. It would be impossible in practical terms for law to consist solely of general rules. You may have heard this, but Raz puts forward what he believes the important principles of law is, such as laws should be prospective rather than retroactive. People cannot be guided by or expected to obey laws that they have not been yet introduced to. Roberto Unger wrote out a typology of social order, which is essentially a rule of law system. distinct to categories such as autonomy and legal order. Autonomy is interesting as part of it has 4 areas. First, substantive autonomy. This refers to the fact that law is not explicable with other non-legal terms. Law is law, it's self-referential. Secondly, institutional autonomy refers to the legal institutions like courts. These should be separate from other institutions held by the state and highlighted in the principle of judicial independence. Thirdly, methodological autonomy refers to the fact that the law has, or at least lays claim to having, its own distinct form of reasoning and justifications for its decisions. Finally, occupational autonomy refers to the fact that access to law is not immediate, but it is gained through the legal professions, who act as gatekeepers and exercise a large degree of independent control over the working of the legal system. The part of legal order is what you would expect. It shouldn't have favoritism. Essentially, everything we've said in this video so far, nobody is above the law. The state remained apart from the civil society, or it pretends to. Its functions could be restricted within a limited sphere of activity within the rule of law. But the state over time has become more involved in regulating economic activity. Therefore, a necessity for the rule of law is to change. The legislation previously took the form of fixed and precisely stated rules. Now legislation tends to be far more open to grant wide powers to particular state functions. Therefore, this leads to less power to the courts to control such an activity. Courts have attempted to prevent this to an extent with introduction of judicial review, but their effectiveness is a bit questionable. The growth of delegated legislation, if you don't know of yet, don't worry about it, I'll explain it right now. It's essentially orders and councils, statutory instruments and bylaws. Delegated legislation essentially allows Parliament to pass enabling acts, empowers ministers of state to make regulations for what they generally consider necessary. The increased use of tribunals with participation of non-experts rather than using traditional courts to decide disputes has been the underlying implication that the law is not really capable of resolving the problem adequately, further diminishing the law's previous power. Legislation also pursues substantive justice rather than formal justice. Substantive justice is that the behaviour or treatment is fair and reasonable, whereas formal justice is being consistent and impartial with the law. An example of legislation pursuing substantive is the consumer law, such as Unfair Contract Terms Act 1977, where contract terms are evaluated to be based on reasonableness. In addition to that, the Consumer Credit Act 1974, agreements can be rejected if it's extortionate. These provisions override the market assumptions as to formal equality, in an endeavour to provide a measure of substantive justice. There is conflict of interest here, as you can tell, as formal equality of wanting to provide a society that is based on fairness. Everyone is always treated equal. The rule of law and its judiciary is highlighted greatly by Senior Lord Bingham.
It's a very important principle. We elect members of Parliament, we give them authority to make laws, they make laws, the laws bind us, but we don't give the people who are given powers by those laws a blank check.
The Constitutional Reform Act that says in Section 1 that the Act does not adversely affect the existing constitutional principle of the rule of law, or that the Lord Chancellor's constitutional role in that principle. Bingham points out that the Act does not define what the rule of law actually is, as you may have deciphered earlier. Bingham's view of that Act is that the authors of the 2005 Act apparently also recognise the difficulty in giving a definition that is suitable. The importance of such an act cannot be underestimated. Bingham believes that the CRA recognises the rule of law as an existing constitutional principle, then the judges will be required to construe laws in relation to that principle. A further implication of the CRA is that the Lord Chancellor's conduct in relation to the role and duty of the rule of law would be open to judicial review, where he be challenged in that regard. As the rule of law is already a constitutional principle of the UK, and one that may be more contentious in the future, it becomes imperative to attempt to define what it actually means. It is this task that Lord Bingham sets himself in the lecture. Under consideration, what he suggests at his core is the idea that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered in the courts. That was a mouthful, Bingham. Bingham continues to say what he believes should be a part of the rule of law and makes 8 implications or rules. So we're going to go into detail about them. Now, don't worry for those who are studying for your exams and down in your last coffee trying to pull an all-nighter. I'll leave a note form of all the proposals in the video. The law must be accessible and so far as possibly intelligible, clear and predictable. Now, everyone is bound by the law and must be able to, without difficulty, be able to find out what that law is. Bingham goes on to blame the system for a lack of informed legislative understanding due to the hyperactivity of governance. Bingham also rejects the benefit of single opinion decisions in the House of Lords with only 1 judgment and 4 decisions in agreement of 5 or more, because it can bring a bear of diversity of professional and jurisdictional experience, which in his opinion is valuable in shaping the law. Now, the benefits of his proposal, he goes on a lot about judicial review and wanting to talk about the Supreme Court and its decisions. That will be a much future video. It is way too long to cover in the rule of law. Sub-rule number 2. Questions of legal right and liability should ordinarily be resolved by application of the law and not the exercise of discretion. So Bingham doesn't really share Dicey's view of discretion and cites immigration law as an example to be advantageous. Sub-rule number 3. The laws of the land should apply equally to all, save to the extent that objective differences justify differentiation. As mentioned just now, it shouldn't be one rule for a British national and another rule for another. Unfortunately, this has been disregarded due to implementation of Part 4 of the Anti-Terrorism, Crime and Security Act 2001, which is incompatible with the Human Rights Act. The law must afford adequate protection of fundamental human rights. Bingham understands that it's a difficult area, that there is not a standard of human rights that has been universally agreed upon. He even admits that this rule that he's said is very, very vague. I just think he's padding up the numbers. The next sub-rule is means must be provided for resolving without prohibited costs or inordinate delay bona fide civil disputes with which the parties themselves are unable to resolve. This isn't an attack on arbitration. I know, I thought so too when I first read this. He actually sees arbitration as really important. He's looking to support provisions of a funded legal aid scheme, which was taken away by the time he wrote this. Bingham also concerned about the fact that multiple governments believe that the civil courts and judicial salaries should be self-financing. As we know, fees are generally recovered from litigants. The next sub-rule is ministers and public officers at all levels must exercise the powers given to them reasonably and within good faith for the purpose of which the powers were actually given to them in the first place. So, for example, a role of a court or the judiciary is to check the executive power. Now, obviously, this is separation of powers territory, and we're not going to go into that too much right now. But Bingham says that the traditional relationship between the judiciary and executive has seen a shift, with ministers being critical of a judicial decision, and then maybe they exercise the rights to appeal it or legislate reverse it retroactively. The next sub-rule is adjudicative procedures by the state should be fair. Well, this seems really obvious, but he compares it to the United States of America, in which democracies die behind closed doors. Shakespearean. The judges should be independent in the sense that they are free to decide on legal and factual merits of a case. In addition, a person subject to liability should be well informed of what is said against them, and the accuser should make adequate disclosure of all the material helpful to the defendant or damaging to the prosecution. Now, this is a an issue in criminal law even today due to disclosure. So public interest is, you're very unwilling as a prosecution to disclose evidence to the defendant. I mean, if the law says you don't need to, why would you? And also the reverse burden of proof. There's some offences that believe that there is a reverse burden of proof in which the defendant has to show that they did not commit the offence. If you're looking for more information on reverse of burden of proof, I would highly recommend Regina versus Lambert. And the final sub-rule is the existing principle of the rule of law requires compliance by the state with its obligations in international law. Now, in the lecture I showed earlier a clip of, Bingham has an indirect way of examining the involvement of the UK in the ongoing war in Iraq at the time. He suggests that it was a breach of international law, and therefore, if his sub-rules are sound, the rule of law itself. He did this by comparing the scenario to the Suez Crisis in 1956. And that concludes the rule of law. There isn't any definition of the rule of law, as you can tell. It's quite literally just some opinions from extremely intelligent people. But what's your opinion? Tell me what you think what the rule of law actually means or what it represents. In addition, I've left timestamps on this video in case you missed anything. But then again, thank you for watching, and I hope to see you soon.